Hi, thank you so much for joining our webinar today. My name is Jessie Peterson. I'm the Director of Education here at SunRay Construction Solutions. SunRay secures $10 billion annually for GCs, subs, and suppliers. We are a national construction document service. Today's webinar is conducted by the wonderful Alex Barthet, a Florida construction lien law expert. Today's webinar topic is 2025 New Year Credit and Collections Best Practices. So without further ado, I'd like to introduce the wonderful Alex Barthet.
Thanks, Jesse. My name is Alex Barthet. I am a board certified construction attorney here in Florida. And today we're going to talk about the 2025 New Year Credit and Collection Best Practices. What do we see clients do right? What do we see clients mess up on that they can improve? We're going to go through it in great detail. So let's get started. To the extent you have any questions, you should have the GoToWebinar chat box on the right-hand side. Go ahead and fill in your questions. We will answer them all at the end. Please do not include the names of any companies or people in your question. All right, so what are we going to talk about today? One, we'll talk about the basics. Why is it worthwhile extending credit versus just doing everything COD? We'll talk about ways to check credit, some ways through paid services and some free services, how much credit you should extend, how to prevent problems once you extend credit to somebody, and then we'll talk about some collection tips and tricks that we see that work. And as I said, to the extent you have any questions, we will answer them at the very end of the presentation. So let's talk about some basics. Why should you extend credit? Obviously, customer loyalty is a big thing. A lot of people want to be able to purchase things on credit so that they don't have to come up with the cash right away. That's why we all love our credit cards. It's no different than the situation that you would be in with your customers. Another reason that you should consider extending credit is you can feel secure, and we'll talk about how, that the financial situation of your customer is such that they will be able to pay the amounts that you extend credit to them for. Another reason is it has become an industry standard. In many industries, it is most common to extend credit rather than get paid in advance. So to the extent you're a supplier, you are almost expected to give credit because your competitors are extending credit. In other areas of construction, it is also typical in many instances to do work and then get paid after the work is done, whether that's monthly or for an entire project. So again, the industry standard, what customers come to expect in most instances is that you will extend credit, so that if you don't extend credit, someone else may. You can gain a competitive advantage by extending credit, meaning to the extent someone comes to you and they need credit, they are more likely to purchase from you if you agree to extend credit to them. And obviously increasing sales. It's easier to convince someone to buy something if they don't have to pay for it today. So let's talk about ways that you can check credit. So the very first thing is you need a credit application. If you don't have a credit application, you need to get one or make one, because that is where understanding your customer's credit begins. So you need to know their business name. We represent many suppliers, both local, regional, and national and international suppliers. So they extend credit all the time. I look at a lot of credit agreements day to day, and I will tell you sometimes our clients make mistakes when they get the basic information, and it becomes a problem later when we talk about collections if you make mistakes in your credit application. So number one, you want their actual business name, not John Smith Construction. That may be what they go by, their fictitious name or doing business as name. You need the actual legal entity. So it needs to be end in an Inc., an LLC, a corp, and then you want to get their physical address. Where do they operate their business? Everybody, to open a bank account as a business, you need a federal tax ID. You want to get this ID. The reason that these pieces of information are critical is twofold. One, in order to check someone's credit, you need to know that you're checking the right company's credit, so you need their exact details. And number two, if you ever have to get into collections, then you need to make sure that you know the party that you extended credit to, and having their exact corporate name and their tax ID makes it certain that you're going after the right person. If they have a license to do business, it's also good to get their license number. The reason you want their license number, even though if it's not a legal requirement to extend credit, it will give you additional information to run searches against. So for example, if you extend credit to a plumber and that plumber has a license number, you can check that whether or not that plumber has complaints against their license. That's a good piece of information to know. Someone with many license complaints may not be someone you want to extend credit to. Also, if they say that they are a plumber and they have no license because they can't give you a license number, then you should be curious how they are acting as a plumber without a license. Also someone you may not want to extend credit to. And then you want to get some banks and business credit references. In the good old days, it was much easier to get folks to give you both to get the credit reference from somebody and then to actually check the credit reference. These days, it's much harder in the sense that even if you get a credit reference from somebody, many times when you pick up the phone to try to check on that credit reference, i.e. another supplier or a bank, they are unwilling to give you any meaningful information. It's good to get, but just know that unless you have a relationship, most folks are not going to answer specific information about their customers with respect to the credit that they extend. So once you get this information, you need to actually verify it. Getting the information on a piece of paper and not checking it is completely useless. So it sounds obvious, but once you get all this information, you need to actually verify the information you get. So let's talk about how to do that. You need to get their specific authorization in your credit agreement to pull their background information and credit information. That is a legal requirement. So if I come to you and you want to check my credit or pull my background information, you need to get me to sign an authorization that I am allowing you to do that. So that's just a sentence or two in your credit application, but it is important that it exists in your credit application. So let's talk about some paid services and we'll talk about some free services. So probably the most common is Dun & Bradstreet, dnb.com. You can check someone's credit and credit history by using the paid service of Dun & Bradstreet. TransUnion purchased TLO. That's another service that you can use. Cortera, which is now part of Moody's, is another service. Again, all of these are paid services, relatively inexpensive, but you will pay a fee in order to check that information. Now let's talk about some free services. So at a minimum, you remember I told you want to make sure you get the actual corporate name and their EIN number. And that's so that you can go to the Secretary of State. So we're all in Florida, so the most common place to check is sunbiz.org to check to see, is that business actually registered with the state of Florida? Are they authorized to do business? Are the people that are coming and asking you for credit, are they listed as officers on the Secretary of State? Is the information they gave you in their credit application the same as is listed on the Secretary of State? For example, maybe they say their name is John Smith Carpentry, Inc., and they tell you that the president is so-and-so, but you look online and it's a different person. Or they tell you an EIN number that's not the same that's online. You should be very suspicious. This is why you need to verify the information. Again, pro tip, your contract and your credit application should be in the exact name as it appears on SunBiz. Again, the reason is very important. if I come in and I fill out your credit application and I just say John Smith Carpentry, I don't say Inc. or LLC, and I don't pay, and you have to sue me on this credit app, and I go to Sunbiz and I realize that there's John Smith Carpentry Inc., John Smith Carpentry of Miami LLC, John Smith Carpentry Corp. Which one is it? Which entity was the one that actually is the one that you actually extended credit to? So you want to make sure you get the credit application. It has the information as it appears on Sunbiz. And by the way, if it doesn't, you then need to go back to the person that's asking for credit and say, please, I need you to correct this information. Which of these entities is yours? I need you to update your credit application so we can finish this review. So there are a lot of other places you can check the public records for the information on someone's background. So the county recorder's office has lots of information like liens, releases, judgments, property transfers. So if you are located in Polk County, you're going to Google Polk County recorded documents. It'll bring you to the website where you can search those records in the Polk County recorder's office. You put in the party's name and it'll show you all the documents recorded against them. Most of this information, ideally all of it, should show up in the search that you ran on Dun & Bradstreet or TLO, but it's not guaranteed. If someone entered a judgment against this entity 4 weeks ago, that may not appear on the TLO search report that you paid for. So it's always a good idea to look in the public records in the county where this business may be located to see, are there other recorded documents that are problematic? You want to see if they own any property, so that you're going to check the county property appraiser's website. So the best way to do that is, again, if we go back to Polk County, I'm going to type in Polk County property appraiser in Google. It's going to bring me to their search page, and I'm going to look to see if this entity owns any property. And then the last one is the court records page of the county. So if I'm searching in Polk County, I'll type in Polk County court records, and it'll bring up a search window that will allow me to look for any open or closed civil, probate, family, or criminal cases against either the principals of the business, depending on how I search, or the name of the business. All of that is available to you. All of it, again, should be in the searches that you buy via Dun & Bradstreet, TLO, but it's always a good idea to check these other places. I wish I could tell you there's one place you could go and just do one search and get all of this information. Unfortunately, every county maintains this in 3 separate places, so you have to do 3 separate searches. Google is great as a way to check and find information. So for example, if we're looking for John Smith Carpentry, I would go to Google, I would type in John Smith Carpentry, Miami, Florida, and I'll see what comes up. And I don't just limit it to the first page, I go to the 2nd, 3rd, 4th, 5th page of Google, see what comes up. Google has a tremendous ability to surface information about entities and people. So doing a search for the principals and the companies may reveal information such as online reviews, Better Business Bureau reviews, license complaints, mugshots. All of this information may show up on just a plain old Google search. So make sure you use this also in your credit checks. So how much credit should you extend? Unfortunately, this is not an exact science. There's no people that try to make it an exact science. I would tell you, at least in my opinion, it's more art than science, meaning you may limit someone's credit, and if you extended it even further, everything would be fine, and vice versa. You give someone a credit limit and they never use all of it, but they still can't pay their bill. So it's not an exact science to determine how much credit to give. But here are some factors to consider. How much are you willing to put at risk, right? You have to understand that when you give someone credit, there's the possibility they may not pay it back. You are more likely to extend someone credit if the debt is somehow secured, and we're going to talk about a few ways to do that. You can get a personal or corporate guarantee. You can get a joint check agreement, and you of course have lien and bond rights. So let's talk about how to secure the debt and why securing it should allow you to feel more comfortable about extending more credit. But always start slow. You know, if I come in and I want credit with your business, be cautious about giving me $100,000 line of credit that maybe I don't, that I shouldn't be able to support. Rather, maybe start me with $20,000 and see how it goes for a few months. So let's talk about the first one. This one is probably the most commonly talked about, but also very hard to get in many instances, and that's a personal guarantee. It is a written promise from a person to pay the debts of the business. It can and should include spouses, husbands and wives, but almost always you're just going to get one or the other. It's possible to get both, but it's very rare. And the reason, by the way, you want the husband and the wife is because, at least in Florida, if I own a piece of property with my wife and we own it as tenants by the entirety, just because you get a judgment against me doesn't mean that you can get the property. You won't be able to touch my property that's held between me and my wife, because my wife is not a guarantor on the credit agreement. So if you want to attach or garnish wages, garnish bank accounts, or take things that belong to both the husband and the wife, then you need both of them on the credit agreement. This personal guarantee does not need to be conditioned on the business not paying, right? So sometimes people will tell you, well, the personal guarantee only matters to the extent the business doesn't pay. That's not true. We pursue many, many personal guarantees for our construction clients, and we don't, you know, while our client may ask the company to pay first, when we file a lawsuit to get paid, we sue both the guarantor and the business jointly and severally, meaning they're both independently liable for the debt. So just be careful about that. So you understand that when they sign that guarantee, you can pursue both of them. It can also include all the debts, if it's written correctly, without the personal guarantor's consent. Let me give you an example of what I mean. Let's say I'm helping my son start their business. He has no ability to get credit for this construction business, so I'm not affiliated with his business. He signs your credit agreement. You extend credit to him, but you need a personal guarantee. So you have me sign as a personal guarantor. I'm not involved in the business. He runs up a huge debt. You don't have to get my permission as you extend that credit to him. But now if he doesn't pay, you can pursue me, and I will not have the defense that, well, you didn't get my permission to extend all that credit to him. So that's why a personal guarantee is very important. And it also covers the principals that may have given a personal guarantee that leave. This happens surprisingly often. So let's say I have a partner in the business. In that business, I decide to sell the business to my partner. I don't go through the effort of determining that which credit agreements I may have given or personal guarantees I've signed in the past. I leave the business. He runs it into the ground. A year later, the supplier, you come to me and you say, hey, you left the business, but the credit agreement still said you were on the hook. And that's perfectly legal. So having a personal guarantee means that you can pursue anyone in the business, irrespective of their involvement in the business, if they gave you a personal guarantee. The exception, of course, is that when I leave the business, I can send you a letter and I can say, I'm leaving the business. I revoke my personal guarantee. Do not extend any more credit on my, that affects me. I'm still responsible for any credit that was extended previously, but once I send you that notice, then that would eliminate my liability going forward. You can also get a corporate guarantee. This is a written promise from one business to pay the debts of another business. So maybe I am a real estate developer. Every one of my developments is a separate entity. So I don't show an ability to extend, I don't have the credit worthiness for each of my developments for you to extend credit to me. So you say, you know what? I need the parent company, right? The company that controls all of the companies to sign a guarantee for me for the debts of each of the subsidiary companies. So again, it's identical to a personal guarantee, but it's just backed by a different business. You just want to make sure that to the extent you're to the extent you're extending credit to either to a company because of the personal guarantee or the corporate guarantee, that you do all the same searches we talked about for either the personal guarantor or the corporate guarantor. So let's talk about the next one, joint check agreements. This is a written promise, usually from either an owner or contractor, to pay either a subcontractor or supplier directly as the project goes on. So you don't have to, so the money doesn't go from the owner to the contractor, contractor to sub to you as a supplier. This joint check agreement says that that the contractor, every time he pays the sub, has to pay you your portion of that money. It's governed by its terms. It's just a contract, so you need to read it carefully. I would caution you that if you are signing a joint check agreement that is given to you by someone and they wrote it, it's probably better for them than it is for you. So you need to be very careful about what it says. Many joint check agreements that we review that are prepared by owners or contractors don't actually have a lot of teeth to them if you don't get paid. So as a result, you need to make sure that you read it, and if you don't agree with its terms, you make changes. Something to keep in mind. Most joint check agreements say that the contractor is going to issue a joint check. A joint check is a dual party check. It's a check written to subcontractor and supplier. But what happens if the subcontractor refuses to endorse the back of the check, right? So if you have a dual party check payable to the subcontractor and the supplier, the subcontractor has to endorse the back of the check for the bank to accept it. What if the subcontractor says, no, I'm not signing it. I'm not going to sign that that dual party check. Well, unfortunately then, that check is worthless. It's a piece of paper sitting there and you cannot get your money. So you want to make sure that in any joint check agreement you sign, that to the extent that the subcontractor, the party between you and the payor, refuses to sign, that you can provide notice to the other side and they will issue a single party check just to you, right? So it's kind of like a fail-safe. If someone refuses to sign that dual party check, you go to the person that made the check and say, hey, look, I tried to get the signature, they wouldn't do it. Issue the direct check to me. Again, this is a great little tip to make sure that you actually get the money. All right, so let's talk about the last one, lien or bond rights. A lien encumbers property such that you can sell the property to get paid to the extent you are owed money. A bond claim is a claim against the contractor's payment bond, and to the extent you are not paid, that bonding company is there to secure your right to be paid. So let's go over the timelines. It's always a good idea so we're all on the same page. You need to serve a notice to owner no later than 45 days from your first work or delivery materials on the job. You need to record your claim of lien no later than 90 days from your last work. The same is true for a notice of non-payment, which is the bond claim. It's got to be done no later than 90 days from your last work on the job, and then no later than 1 year from the recording date of the claim of lien. That's when you have to file a lawsuit to foreclose on the lien, or 1 year from the service of the notice of non-payment. That's when you have to, one year from last work to make a claim in a court of law with respect to your bond claim. A pro tip, because I hear this every once in a while, people come to me and say, oh, Alex, the job's not bonded, but it's okay. They have SubGuard or subcontractor default insurance, SDI. So just know that subcontractor default insurance, SDI, or a SubGuard policy does not guarantee, does not protect your right to be paid for materials or labor that you deliver to the project. Lien rights do, a payment bond does, but subguard does not. So just know that if someone tells you, oh, you don't have to worry, there's subguard on this job, subguard protects certain things. It does not have anything to do with you getting paid for your labor or materials. So be cautious about that. Now we have lots of free tools at the Lien zone. So one of them is the Calculien. If you want to get this handy desk tool, you can keep it on your desk, and it helps you calculate the 45 days for the notice to owner and the 90 days from last work. Go to calculien.com and we will send you one for free. All right, so let's talk about how to prevent some problems. You need to rerun credit at least annually. People's businesses change. You know, you go to the doctor every year, hopefully, to get a checkup just to see how things are going. You need to do that for people that you extend credit to. Don't just set it and forget it. You need to check on equipment delivery, status locations. What do I mean by that? If, for example, if you're a rental company, are your sales folks checking that the equipment is where the customer says it is? Do you have tracking information, GPS tracking on your equipment rentals? You know, when you deliver materials to a site, are you checking to make sure that those materials belong to that job? You know, we have a lot of supplier clients, they deliver materials to a project, and unfortunately, that subcontractor then takes that material and goes somewhere else with it. That will negatively impact your ability to record a lien. Meet with your customers, listen to what they're saying. Are they telling you that everything is great, or that they're having problems, cash flow, payroll? Those are all signs that you need to be aware of to make sure that you're extending credit correctly. Communicate with your sales team. So if you're in credit or your management and you don't have interactions with your customers, what is your sales team saying to you about things that are happening in the industry with the business? Again, that type of information is like a canary in a coal mine. Many of our clients will come back to us and say, well, you know, yeah, we did hear about some of these issues before, and you know, we didn't really think they were serious until, of course, they blow up. You need to keep very good records. If you have to go to court, your record keeping is going to be important. Probably one of the most contested issues that we see is that you have no good delivery tickets, especially for suppliers, right? So the delivery ticket shows that it was delivered, and the only thing that's on that delivery ticket is a squiggle. A monkey could have done it. It's not a name. There's no information about who received it. And if someone wants to contest that the materials were actually delivered, then that delivery ticket becomes important. So just be careful that you are keeping good records with respect to what you do. Here's a pro tip: do not list the credit limit on your credit application. So to the extent you decide to extend someone credit of $10,000, my advice to you is do not write on the credit application credit limit of $10,000. Also, do not ask the customer how much credit you want, or that you want them to ask you for. The reason that you don't want to do this is that there's some case law in the state of Florida that suggests that if you give someone an amount of credit and they exceed it and don't pay, or vice versa, they ask for $10,000 and then you agree over time to give them 20 or 30 and they don't pay, they will use that as a defense against you. They will say, well, I only asked for $10,000. You gave me $50,000 worth of credit. You shouldn't have done that. You know, so therefore my liability should only be $10,000. Again, in my opinion, that's blaming the victim. You extended credit, they should pay the bill, but those are defenses that you may see in a court case. There are ways to mitigate that defense, and one of the best ways to do it, again, it's not that you don't set any credit limit, is you just don't have that information so openly available for the other side during the course of a litigation. Let's see, I went backwards. All right, so let's talk about some basic collection tips. Contact the delinquent account holders often. Do it verbally, do it in writing. Be nice, but be firm. The squeaky wheel gets the grease. Our most successful clients at collections are persistent. So don't be afraid. Don't be bashful. You worked hard to earn this money. They should pay you. You need to be diligent in collecting. Try to negotiate with the actual decision maker. It's very frustrating to negotiate with someone who then says, oh, well, let me check. I have to get back to you. Everyone ultimately has a boss that may be different from them. There's a board of directors. I have to check with my business partner, my spouse. That's fine. However, if you're negotiating with a administrative assistant to try to get paid who has no authority, you're going to end up negotiating over and over. So make sure you try to negotiate payments with the decision maker. So if you're talking to an administrative person, say, do you have the authority to resolve this matter? If not, I want to speak with that person, him or her, directly. Condition any credits on prompt payment. So be very careful about giving an unconditioned credit based on a verbal promise. I owe you 50,000, you agree to take 30 so long as I pay you in a week. I say, please send me a credit memo so I can give it to my accounting department, and then I'll go ahead and pay you the 30 against the 50. You do that, and then I never pay you the 50. And then you go to your lawyer and say, hey, I want to sue them for 50. But now we have this credit memo, this unconditional credit memo in the file. It becomes a problem. So on the credit memo, you want to write something like, this credit is expressly conditioned upon the undersigned's receipt of payment of $10,000 by May 2025 or May 25th, 2024 in cleared funds. Otherwise, this credit memo is void. So it's very clear. I'm giving you this credit because you're going to pay me by a date certain, such that if you don't pay me by the date certain, this credit goes away. You can do it via email too, right? So here's an example. As discussed this morning, we will accept a payment of $10,000 against the $12,500 that's owed only if payment is received by this date certain in cleared funds. Again, setting forth the agreement in writing so that if the agreement doesn't happen, you haven't given anything away. You also want to make sure that all the releases that you give to someone during the course of a job, but especially when there's a problem, are conditioned on payment. And to do that, one of the best ways is to get our free makemeconditional.com stamp. So if you go to makemeconditional.com, you can get this stamp here where it will stamp the conditional language on your releases. So if you're expecting a $28,000 check, you stamp the release, you write $28,000 in the blank, and now this release is conditioned on you actually getting that money. Don't delay in initiating the legal process. If you are not making headway, do not wait to enforce your legal rights. Hire a lawyer and file a lawsuit as quickly as possible. Now, I generally suggest that you try for 30 or 60 days after you record a lien or serve a notice of non-payment to try to get paid. I don't mean you file your lien and then you hire a lawyer the next day. Now, maybe you decide to do that, but there should be some ample time that you try on your own. But after that, every day that goes by makes it that much harder to collect the debt. So one of the things we just released that you can try is a free AI Florida lien law chatbot. So if you have questions about the lien law, if you go to chatbot.thelienzone.com, you can ask your question and it will give you an answer. It's not legal advice, it just will give you some basic guidance, but it's a good place to start to check to see, to get answers to the questions that you may have about lien law timing, contract issues, and collections. All right, Jesse, with that, we are done. Do we have any questions to answer?
Well, first of all, you were incredible as always, so I do appreciate that. We do have a couple of questions that came through, and it says, this is not about the credit, but if you do not know the complete entity name, can you still file your lien?
The answer is yes. The answer is yes. It becomes a little more complicated because you're going to have to write the owner of the property on the lien, and you're going to have to say who your customer was, right? So we can always find who the owner is because we'll look on the property records, right? So if I did work at 123 Elm Street, I can determine who the owner is. Who ordered the work? you're going to put the best information you have. It may become problematic later, but the answer is yes, you still have lien rights if you delivered product, even if you're not exactly sure the corporate name of who you sold the materials to.
Okay, thank you. Another question that came through, do you feel there is a dollar limit where it is not worth filing a claim of lien?
It's different for everybody. I would say probably less than, I would say $1,000 or $2,000. It may not be economically feasible. You have to look at the cost to hire someone like SunRay to prepare your lien and to record it. And the lien is not self-executing. Once you put a lien on, it sits there. So unless it bothers someone because it's a default on their mortgage or they're trying to sell or refinance, it just sits there. So that's my take. But we have clients that will lien for $700, and we have other clients that say, well, it's not worth it if it's less than 10,000. So it's a personal decision.
Perfect. Okay, and then it says, if you do not know if there is a spouse or the name of the spouse, should you list any unknown spouse on your notices?
You could say unknown spouse, but it's not really required on the notice. So if we're talking about notices to owner, the answer is no. You would list who the owner is as referenced in the notice of commencement and in the public records. That's the owner of the property. And then with respect to your customer, you're going to list whoever you sold the materials to. So if you did work at my house and my house is owned by my wife and I, then in the notice to owner, you would include both of them as the owner of the property, but that's what's revealed in the public record and should be revealed in my notice of commencement.
Wonderful. And then another question that just popped in is, if the work was done more than 90 days ago, do you still have any right to sue?
Absolutely. So the 90 days is just your right to record a lien. You still have many other legal rights, right? So for example, you could sue the owner for a legal theory called unjust enrichment, which is I provided materials to your property and I didn't get paid. So I may not have a lien, but I have a equitable interest in recovering the money because you have my stuff and I haven't been paid for my stuff. You also have a breach of contract claim against whoever bought the materials from you. So if I'm a supplier and I delivered materials and as a result, I didn't get paid and I lost my lien rights, I can always sue the person that hired me or bought the materials from me based on either my credit agreement, which is my contract, or if we have a separate agreement. The reason that liens are nice is it creates an encumbrance on the property, so it's a secured interest. It limits the number of defenses that the other person can assert because, for example, there's lots of defenses on these other claims I'm talking about, unjust enrichment. On a contract, maybe there's a pay when paid provision. So securing your lien rights is paramount, but all is not lost. If you did not secure your lien rights, you absolutely have other potential legal theories.
Wonderful. That seems to be all the questions that have come through thus far. If anyone does think of another question that wasn't addressed, please feel free to reach out to us. We'll be sure to answer any questions that come along. Can you go to the next slide for us, please? All right, so here are some of SunRay's resources to help you stay organized, know your deadlines, and secure your lien rights. Go ahead and scan that QR code to access these incredible resources. We have the free project information sheets. It's going to help you guys get your information right off in the beginning of your project to make sure that you know everybody who's working and associated with that project. We have the lien laws maps that will tell you on nearby states of what type of a project you're working on, what your role is, and what the documents are. Remember, each state has its own unique lien laws and deadlines associated with that. So please check that out. There's a deadline calculator. There's so much on there. So please go ahead, feel free to scan that code and check out all those resources available to you. All right, our next webinar with Alex is going to be 7 deadly lien and release traps and how to beat them. That's February 20th on a Thursday. And then the one after that is your lien is worthless on tenant buildouts, and here's why. That's going to be on June 17th. So please go ahead and register for free at sunraynotice.com/education. Our next seminar with Alex, this is a live seminar, is going to be on March 13th. So if you're in the Boca area, Alex is going to be presenting alongside of Ariella for a live seminar on how to get paid faster with liens, bonds, and contracts. If you're interested, register at sunraynotice.com/seminar. We will be having additional seminars in Fort Myers, Orlando, Tampa, and then a couple in Miami as well. So please go on our site and check them out. All right, and then if you don't mind, scan this QR code. I would really appreciate it if you can give us some feedback. We really appreciate hearing what your thoughts are. It helps us get some more information out there for you guys and some different topics that you want to hear. Another question that was just posted, Alex, it says on there about the presentation, you guys will have access to this video. It will be sent to you. And if you would like to have the actual presentation, please contact me and I will reach out to you. With that, that is all we have for you guys today. Thank you so much for everyone who did attend. We hope to see you at our next webinar. I hope you all have a beautiful and wonderful sunny day. Thanks again, Alex.